Hello everyone, welcome to our concluding presentation on tort law. This is our presentation on Chapter 7, Part 2, and again we're talking about tort law. Let's get started. So first let's talk about intentional torts against property. So intentional torts against property, we're talking about trespass to realty, which is a fancy way of saying real property, and which is another fancy way of saying land. Private nuisance, trespass to personal property. So personal property is like your watch, necklace, things like that. And conversion. So trespass to realty. Now this is from your book. Let's go ahead and read this definition together. It occurs, trespass to realty or trespass to real property occurs when a person intentionally, 1, enters the land of another without permission, 2, causes an object to be placed on the land of another without the landowner's permission. 3, stays on the land of another when the owner tells him to depart. Or 4, refuses to remove something he placed on the property that the landowner asked him to remove. So with trespass, there has to be intent. There has to be intent to be on the property. And a defense to trespass is that you were welcomed on the property. But again, if you're welcomed on the property and then told to leave and you don't leave, well, you're back committing trespass again. Typically, a trespasser cannot recover damages for injuries sustained while on the owner's property. So again, in my work representing as an attorney for Speedway, we were always concerned about why someone was on our property. Were they an invitee, a licensee, or a trespasser? We're going to talk about those other things in a little bit, but we were curious to know why we're there. And again, we'll talk about this later, a trespasser was owed the lowest duty of care of those three. So again, important as to why somebody is on your property. If they're uninvited, if there's no reason that they should be there, then they're probably going to be a trespasser. Let's talk about something called a private nuisance. So a private nuisance is when a person uses their property in an unreasonable manner that harms another's use of their property. So an example of that is if you installed a pool and in the course of installing your pool, you diverted water and flooded your neighbor's property. That would be a private nuisance. Let's talk about trespass to personal property. We've talked about trespass to real property, which is land. Now let's talk about trespass to personal property. And this bike is an example of something that would be personal property. Now I'm going to talk about the bicycle here, an example, a variation of the example that your book uses. But your book also describes this trespass as temporarily exerting control over another's personal property or interfering with the true owner's right to use the property. So look at that word temporarily here. We're going to talk about in conversion in a minute, and that's permanent. But this is temporarily exerting control over another person's property. So a person's playing a practical joke, they hide my bike. That person who hid my bike may be liable for damages for the wages I lost because I couldn't use my bike to fulfill the duties I had as a newspaper delivery person. Okay? So again, trespass to personal property. Just a variation on that, again, we've talked about this. If you permanently take my bike, then that would be conversion. Okay? Taking my bike permanently would be conversion. Again, another variation is if you thought the bike, which looked exactly like your lost bike, was yours, it's still conversion if you fail to return it. Now let's talk about negligence. And a lot of, at least my experience with the law and my career, dealt with these issues of negligence. When somebody injures themselves on a store owner's premises, you're probably talking about negligence. And when you talk about negligence, you're talking about duty, breach, causation, and damages. Okay, duty, breach, causation, and damages. Now, the level of duty you owe to someone depends upon their status. And I briefly mentioned these before. So we're going to look at invitee, licensee, and trespasser. Well, an invitee is owed reasonable or ordinary care. So you can see I have a picture of a convenience store. And so somebody coming into a convenience store to purchase food or other convenience items or to get gas, they are going to be an invitee. They are there upon the owner of the store's invitation. So you can see that definition there from that case I've listed. An invitee is a person who comes upon the premises of another by invitation, express or implied, for some purpose which is beneficial to the owner. Licensee. So a licensee is in between the invitee and a trespasser. A licensee, according to your book, is for a licensee, the owner has a duty to warn of any danger, any hidden dangers, of which he knows but has no affirmative duty to inspect for hidden problems. So a licensee is someone like, and you can see I've listed that there at the bottom, a door-to-door salesman. You haven't necessarily invited them on your property. They're there really for their own benefit, but they're not a trespasser. So that second bullet, a licensee, and this is from that case again, a licensee is one who enters the premises of another by permission or acquiescence for his own pleasure or benefit and not by invitation. So again, they're not owed that standard of reasonable care. Going back to that top bullet, the owner has a duty to warn of any hidden dangers of which he knows but has no affirmative duty to inspect for hidden problems. So that's less of a duty than what you would owe an invitee. Finally, let's talk about the duty owed to a trespasser. And again, this is from the Ohio Revised Code. The possessor of real property does not owe a duty of care to a trespasser on the property except to refrain from willful, wanton, or reckless conduct that is likely to cause injury, death, or loss to the person of the trespasser. So again, that's the lowest standard of care of the three that we've been talking about. So you have to have a duty, and then in order to succeed on a cause of action of negligence, you have to have breach of that duty, and then the breach of that duty had to have caused the damage incurred by the person. So once a duty is owed, there must be a breach and there must be causation. Okay? The breach must have caused the damages. So we're talking about here actual cause or but for cause. I like this old quote. I'm not sure where it came from, but let's read it together. For want of a nail, the shoe was lost. For want of a shoe, the horse was lost. For want of a horse, the rider was lost. For want of a rider, the battle was lost. So really, are we talking about the fact that losing a nail in a horse's shoe caused the loss of a battle? Well, there seems to be some causation there, but for there to be real causation that we're talking about that necessitates the award of damages, that necessitates liability, there has to be not only actual cause, but something we would also call proximate cause. I think this case of Smith versus Hess is a really good example of causation. This is a case involving a three-car pileup, if you will. Smith being in the first car, he was rear-ended by the second car, and the second car was rear-ended by a car driven by Hess. Now, Smith, after this chain reaction accident occurred, was talking to an officer, and it was taking quite a while for things to get resolved. And Smith explained to the officer that he really needed to use the restroom. Well, things continued to go on, and finally Smith again said, "I need to use the restroom." And so the officer told Smith to go ahead and go over the guardrail, go down the hill, and use the restroom out down the hill. Well, Smith did that, but unfortunately in the course of going down the hill, he slipped and fell and injured his shoulder. Now, Smith sued Hess, claiming that Hess was responsible for Smith's shoulder injuries. What do you think? Could Smith succeed on that? Was there causation between the accident caused by Hess and Smith's injuries that he incurred while he was trying to get down the hill? Let's look at what the court said. So remember, we talked about there needs to be causation, not only a but-for cause, but there also needs to be a proximate cause, okay? So Hess hitting the second car not only needed to be the cause of Mr. Smith's injuries, but they needed to be the proximate cause of his injuries. So here the court explains the proximate cause element ordinarily is established where an original act is wrongful or negligent and, in a natural and continuous sequence, produces a result that would not have taken place without the act. The court goes on to state whether an intervening act breaks that causal connection, breaks the causal connection between negligence and injury, depends upon whether the intervening act was reasonably foreseeable by the one who was guilty of the negligence. The Smiths concede that Smith's shoulder was injured not by the impact from the rear-end collision, but as a result of Smith's fall down an icy hillside. They nonetheless maintain that such injury was a reasonably foreseeable consequence of the chain of causation put in motion by Hess's alleged negligence, such that any subsequent negligence of Smith or others that may have contributed to the injury did not extinguish Hess's liability. And then the court said they disagreed with that. The court went on to say, although the Smiths assert that it is certainly foreseeable that an individual with prostate problems would have to urinate after a traffic accident, the facts do not support a conclusion that Hess could have anticipated as reasonably foreseeable that an occupant of one of the vehicles involved in the subject crash would have such problems and thereafter would attempt to traverse a steep icy covered slope next to the roadway in order to empty his bladder. Smith's own conduct in choosing to brave the icy hillside was a new and independent act that took him from any zone of danger created by Hess and introduced risk of his own making, thus interrupting any sequence set in motion by Hess's alleged negligence. And I think another way we would say that is that Hess's alleged negligence was not the proximate cause of Smith's shoulder injuries. Let's talk about damages. Remember, we talked about there's 4 elements of a negligence case. There's duty, there's breach, causation, and there has to be some damages. The damages that are available are compensatory damages, nominal, and punitive. And this should sound pretty familiar. I think we talked about these when we talked about contract law. So really there's 2 forms of compensatory damages. There are special damages and general damages. Those special damages are things like medical expenses, lost wages, property loss. So let's say somebody slipped and fell again at a convenience store and they broke their ankle. Well, they would have medical expenses, probably. They may have lost wages if they couldn't go back to work for a while. And perhaps they were wearing a watch or something and they damaged that watch when they fell. So there would be some property loss. So those are special damages. General damages are usually more costly to the owner of a property, and it's going to be something like pain and suffering. So the person who broke their ankle not only is incurring medical expenses, very objective, but they've also incurred pain and suffering. It's painful, and they suffered through that. And so damages can be awarded to compensate the person who fell for their pain and suffering. There could also be emotional distress, could also be loss of enjoyment of life. Pain and suffering is the big one here. And then, of course, loss of consortium, which is something that their spouse could bring. Then there's also nominal and punitive damages. Again, we've talked about these. Nominal damages are just a minimal dollar amount. I think I saw recently that somebody was awarded $1 for something. That would certainly be nominal damages. It's just an acknowledgement that some wrong has been committed. Then there's also punitive damages, which, as you know, is to punish or to deter future behavior. Both of those, really, to punish and to deter behavior. Res ipsa loquitur. So res ipsa loquitur is a legal term, and it means to infer negligence where direct evidence of negligence is lacking. And so from the restatement of torts here, here's an illustration. A buys at a grocery store a can of spinach packed by B. While eating the spinach, A is injured by a large piece of glass concealed in it. There is evidence that nothing was done by A or by any third person after the can of spinach was opened, which would account for the presence of the glass. Without other evidence, it may be inferred that the presence of the glass was due to the negligence of B. So again, there's an inference of negligence here. It couldn't be anybody else. So that's where this doctrine of res ipsa loquitur applies, the inference of negligence when direct evidence is lacking. Negligence per se. Your book talks about this as being negligence in and of itself. So an example of this would be a violation of a statute designed to protect someone, like the plaintiff, from a certain type of harm. That would be negligence per se. So dram shop laws, laws that outlaw selling alcohol to minors. So if a store owner violates that law and does sell alcohol to a minor and there's a subsequent accident, well, the store owner could be held liable under this doctrine of negligence per se because they violated the statute in selling to a minor. Let's talk about defenses to negligence. There's contributory negligence, comparative negligence, assumption of the risk, good Samaritan, and superseding intervening cause. Let's talk about that last one first, because I think that Smith versus Hess case would be a good example of superseding intervening cause. I think the act of Smith going down the hill was that superseding intervening cause that relieved Hess of liability for the shoulder injuries. Contributory negligence. This is where if the plaintiff's negligence, they're totally barred from recovery. That's pretty severe. So you can see from the site I've listed there, only 4 states and the District of Columbia recognize contributory negligence. So this means that if the plaintiff is at all negligent, they're not going to recover anything. Comparative negligence is a little bit different, and there's 2 types. There's pure and there's modified. Under pure comparative negligence, if the plaintiff is 51% at fault and the defendant is 49% at fault, well, the defendant is liable for 49% of the plaintiff's damages if they're found liable. Modified is if the plaintiff is 51% at fault and the defendant is 49% at fault, well, then the plaintiff gets nothing. So a modified version of contributory negligence, really. Let's talk about assumption of the risk. So this is where You defend yourself if you're an owner of property by saying that the plaintiff assumed the risk of injury. And there's two types, an express assumption of the risk and implied assumption of the risk. Express is where you sign a waiver or something like that. And implied is where the activity is just inherently risky. So you assume the risk when you partook of the activity. I found this interesting. An example of assumption of the risk is in Ohio with this Ohio statute. This is from the Ohio Revised Code, and it talks about roller skating. Let's read it together. The General Assembly recognizes that roller skating as a recreational sport can be hazardous to roller skaters regardless of all feasible safety measures that can be taken. Therefore, roller skaters are deemed to have knowledge of and to expressly assume the risks of and liability for any losses, damages, or injuries that result from contact with other roller skaters or spectators, injuries that result from falls caused by loss of balance, and injuries that involve objects or artificial structures properly within the path of travel of the roller skater, which are not otherwise attributable to an operator's breach of his duties pursuant to, and it gives two sections of the Revised Code. So what's going on here is that Ohio law is saying that roller skating is just so inherently risky that the owner of a roller skating rink is not going to be responsible for injuries to roller skaters. But they do carve out something there, and you see in that last sentence, unless the operator breached the duties that are contained in these sections, and those sections are about posting required signs and having floor supervisors. So again, talking about the fact that under Ohio law, roller skating is a risky activity, and if you injure yourself, then you're probably going to be deemed to have assumed the risk of those injuries and not be able to recover against the rink owner. Good Samaritan statutes are also defenses to negligence. And here you can see a section of the Ohio Revised Code. It says, no person shall be liable in civil damages for administering emergency care or treatment at the scene of an emergency outside of a hospital, doctor's office, or other place having proper medical equipment for acts performed at the scene of such emergency unless such acts constitute willful or wanton misconduct. So somebody treating somebody else out of the goodness of their hearts are probably not going to be liable unless those acts that they performed constitute willful or wanton misconduct. And finally, strict liability. This is activity that's so inherently dangerous, you're just going to be liable no matter what. The book gives two examples, dynamite, and they also allude to dog bite. So, and here's a section of the Ohio Revised Code. Strict liability for dog bites unless the person bitten was committing or attempting to commit criminal trespass or another criminal offense other than a minor misdemeanor, or was teasing, tormenting, or abusing the dog on the owner's, keeper's, or harbor's property. So in Ohio, if your dog bites someone, you're going to be liable for the injuries sustained by the person who was bitten, unless it falls into one of these categories. That concludes our presentation on tort law. Thank you for your attention, and we'll see you next time.